Let's start. Good afternoon, everyone, and a warm welcome to today's webinar on turning disputes into opportunities. Discover the transformative power of arbitration. It's my privilege to introduce our esteemed speaker, Mr. Mohit Saini, a seasoned legal professional with a Master's of Law in Criminal Law and a graduate from Sharda University, where he was honored as the Vice Chancellor's Gold Medalist. Currently, he is serving as an assistant legal advisor at TransJet Cargo Pvt Limited, where he plays a pivotal role in managing corporate legal compliances, policy development, and complex dispute resolution, including arbitration proceedings. He has previously represented clients in litigation before Supreme Court, High Court, and other forums, and bring hands-on experience in negotiating multi-million-dollar claims and overseeing regulatory matters. His academic contribution and practical expertise make him uniquely equipped to guide us through the nuances of arbitration in today's legal landscape. So, over to you, Mohit.
Hello, everyone, and thank you, Divya, for this introduction. And I'm thankful to everyone for giving me this opportunity. And today we are going to discuss a dispute topic which is very relevant in today's time. That how arbitration, though we lawyers are known for turning disputes into the opportunity, but today we are not going to talk about ourselves, but a topic arbitration, which is uh, very much in the trend, and people are talking about it, and some companies and world over globally, we are seeing that there's a global recognition of arbitration as a preferable resolution method. So, in today's topic, which is turning dispute into the opportunity, transformative power of arbitration, this topic is very relevant in today's time, be it a uh, be it a territorial dispute, technology dispute, IP dispute, commercial contracts dispute. There are very different disputes which are now being resolved through the arbitration, and arbitration is playing a major role in that. So, transformation means that transforming from the traditional court proceeding to the arbitration, because the court proceedings are nowadays very much expensive, time taking, slow, and there are a lot of complex issues involved in the court proceeding, because at time when you are a tech company, you are a big commercial company, so you have a lot of things which you don't want to disclose in the public, but when matter reach out to the court, then definitely there are a lot of public disclosure of certain things which you don't want that. And I think the very much talk about dispute nowadays is Indus Water Treaty. And let's see whether Pakistan evoke or take this to the arbitration court, because we do have an arbitration clause in that particular treaty. So that's how we are going to start with our topic. Let me just share my screen. Is it visible?
Not yet.
Let me just share. Now it is visible.
Yeah, now it is.
Yeah. So we are discussing a topic, a turning dispute into opportunity, a transformative power of arbitration. So this is a very much relevant topic in today's time, because the arbitration is the major gameplay. Arbitration is ruling the industry and the legal industry and the dispute resolution industry, because now people don't want to go to court. And I think whether it is United States or whether it is India, the justice delivery system is very slow, very time taking, very expensive. So nowadays, the party, and especially the commercial parties and especially the commercial entities, they want the dispute to be resolved outside the court, and in a very quick manner, where there are no complex procedures, where we don't have to go to the court procedures, hearings. We have to take whether judges on the leave, whether there's a public holiday, whether there is something adjournment is needed. But in arbitration, we decide the procedure, we decide the forum, we decide the venue, we decide everything. So that's how arbitration is now ruling the industry, and a lot of researchers, whether legal researchers, different researchers are now researching upon the topic, that how to make this topic most preferable, how to make this sort of resolution most preferable in the country across the globe. So we'll in coming time we'll see that arbitration will be the major talks in the town. Whether going to the court, we have a saying, "Let's see you in the court," rather than people will say, "Let's see you in the arbitration." So definitely we need to change, and now the society is transforming. Definitely the commercial companies and The commercial entity is now transforming from the court to the arbitration tribunal. Now they are approaching to the arbitration tribunal, evoking this clause in their agreement and reaching out to the tribunal for the justice and in a very quicker justice. So in today's lecture, we are going to discuss the understanding the concept of arbitration. I know many of you know about what is arbitration. It is very simply because we are learning from our law schools. And those who have joined from the law school will learn what is arbitration, what are the basic concept of arbitration. Now, juristic and scholarly disclosure about the arbitration. Arbitration versus judicial process. That how the judicial process is much expensive, costly, time taking, complex procedure, and how arbitration is less formal, more quick, and less expensive than the litigation. Now, empirical data, we do have an empirical data in service which shows that why arbitration is the most preferable resolution. And then we have some case study to discuss. Now, coming to what is the arbitration? Arbitration is a method of resolving dispute outside the court system. It involves one and more neutral parties and third person called arbitrator who hear both the sides of disagreement and make a binding and non-binding decision. So in arbitration, generally, it is opposite to the traditional court system. It involves one or more neutral parties, third parties as an arbitrator, and who will hear both the sides of the disagreement, who will hear both the parties and their pleadings and their arguments, and then will come to the binding and non-binding decision. The key feature that we have in the arbitration is the private. It is unlike the court procedure. Arbitration proceedings are private and they are confidential. They are not in the public scrutiny because certain times in the IP industry, especially in IP industry and very heavy commercial contracts, it has been seen that the parties doesn't want to go to the court because of the confidentiality involved in it. So when certain matter goes to the court, it becomes accessible to the public. The contract become accessible to the public. They become the talk of the town. So definitely they want to save that thing, and that is why the arbitration once again become the most preferable method. Then the voluntary and mandatory parties may agree to the arbitration through the contract, or that may be required by a law and regulation. It can be both. So arbitration may be by through a contract. Generally, like employer and employee have the arbitration through the contract, or it may be required by the law. Then there can be neutral arbitrator. There will be a neutral arbitrator. The arbitrator is typically that arbitrator is chosen by both the party. Both the party will appoint the arbitrator, and that arbitrator is expected to be impartial and neutral. Then it is a must faster and less common. Definitely, the process is not as complex as the traditional litigation complex. Because if you see in the litigation, you have a lot of civil code, criminal code, and you have a laws subject to the particular act like Court of Small Causes, Court of Consumer Act, and you have to govern to that procedure. Even the certain courts have their own procedure. If you go to the High Court, you have a different procedure. If you go to the Supreme Court, there is a different procedure, and if you go to the lower court, there is a different procedure. So every court follows its own procedure. Though we have a standard procedure in CPC and CRPC, apart from that, there are certain things which are very different. So in arbitration, you don't have such things. In arbitration, you decide the procedure, you govern the law, and you make the rules for the arbitration. Now come, it is a binding decision. In most of the cases, arbitrator decision is called a final. It is unlike and enforceable like a court decision. And in certain cases, there are appeals. Appeals are allowed in certain cases. So the most common use nowadays we see in the arbitration is the commercial contracts, international trade dispute, labor employment disputes, consumer contract, IP dispute, maritime dispute, and now I think territorial disputes are also included in the arbitration. Now the countries are reaching out for the arbitration. Sports, I think sports is also becoming the core of arbitration of sports is also much talk about in town. So people nowadays everything, even the environmental law and environmental dispute are reaching out to the arbitration for the amicable resolution and the environmental justice. Let's come to some jurist view. This one. Let's come to the jurist view. Arbitration is not, if you see the Lord Mustil, arbitration is not an alternative to the litigation. It is a system of justice in its own right. So the justice is saying that arbitration is a parallel form of dispute resolution rather than an alternative. It is not an alternative. You have a litigation in place that is going on. and you have an arbitration which is also an equal to litigation, parallel to litigation. So they both have their own merits, demerits. I'm not saying that every resolution method is a perfect and arbitration is not perfect. No, there are advantages, there are disadvantages, but it is not alternative according to the justice, according to the lordship, but it is also a parallel to a justice system, parallel to a traditional litigation system. Now, if we come to the Justice Sandra Day, according to her, the advantages of arbitration are well recognized. It is speedy, it is economic, or it is finality. So there are three things involved in the arbitration, which is the speed, because in arbitration, issues are resolved much quicker and much faster because less complex procedures are involved in arbitration. Parties decide the procedures. Definitely, there are costs on hiring the or appointing the arbitrator. But if you compare to the litigation system where you keep on having the hearings years after years, then you will see that there is a much expense in the litigation rather than the arbitration. And definitely the finality. Obviously, there are chances of appeal in the court because the appeal as a right is given in certain cases to the constitution by statute. But if you see in the most of the cases, the arbitral awards are finals and they have a finality. If we come to the next view, the international arbitration is the preferred method for resolving cross-border dispute because of its neutrality, flexibility, and enforceability. So if we see in the international arbitration, in international disputes, especially when there are a cross-border dispute, the most preferable method is arbitration because it is neutral, it is flexible, and it is enforceable, and it is much preferred by both the parties. And then arbitration. Next view is arbitration is the foundation of free society. It replaces the sword with reason dialogue. Definitely, if you see in litigation, when you bring the party to the court and when you summon them for the courtrooms and the court proceeding, then definitely there are less chances for the reasoned dialogues. But in arbitration, it is much amicable resolution. It is not that harmful decision, harmful as litigation because in litigation, court may impose penalties on the one party and that will not be perceived good as a business relationship. So there are less chances to rebuild that relationship once you reach out to the court for the resolution of the method. But in arbitration, when both the party appoint the arbitrator and there is less public scrutiny and there's less harm to the reputation of the party, and the decision are generally given which are preferable to both the parties. So then there are chances of reasoned dialogue. Arbitration is not perfect, but it is the best option available. Like I've said earlier as well as arbitration is not a perfect. I'm not saying that this is the best option available. It is not the perfect, but it is the best option available in the public. If you see alternative to the litigation, or to parallel to the litigation, if we go, then definitely in commercial disputes, in many disputes, arbitration turn out to be the best option. Let's suppose if there is a logistic industry where our cargo is stuck and we have to reach out to the resolution, then we can't wait years after years because the cargo or the shipment may have an expiry date. And if we reach out to the court, that will not have a that much quicker response that our arbitration may have. So definitely arbitration is the best resolution. There is a construction project, let's suppose, going on. And we'll talk about these cases in the coming slides. And there's a construction project going on, and let's suppose there's some issue between the two parties. Definitely, we'll reach out to the court that will result in a multi-million loss to the company. So definitely, to prevent that loss, we have to invoke the arbitration clause in the agreement, and that will have a much quicker response. Then we come to the arbitration is the preferred method for resolving international dispute because it respects the autonomy of the parties and offer finality. Definitely, every party have its autonomy involved in the case, and when the case goes to the courtroom, and when there is a public hearing, there are a lot of media trial. There are a lot of media trial against the commercial entities as well. So they have to go through that. So in order to prevent that, in order to prevent the sanctity of the business and the autonomy of the parties and the finality and the quicker response and less complex procedure, then the arbitration is the most preferable method in the international dispute. The great advantage of arbitration is that it avoids slow, costly, and complex procedure of ordinary courts that we have discussed already. In arbitration, the party chooses their judge and rules that govern their dispute, and empowering features seldom found in litigation. Then, in courtroom, definitely the state appoint the judges, and the judges are appointed to different methods. But in arbitration, party appoint the judges, and why this is so important because every judges does not have the and may not have the that much knowledge or that much industry expertization. But in arbitration, we do have the industry expert who will become an arbitrator, and that will help us. That will help the parties to get a more quicker justice and the more deeper resolution and more reasonable resolution of their dispute. Because at times judges lack the knowledge, because we can't expect every human to be a expert in every domain. So definitely, in arbitration, appointing judges by the party turn out to be a very good decision, because at times industry experts give valuable solution and the reasonable solution, even the amicable solution between two parties, which a judge may not give. Thirdly, arbitration offers privacy, speed, and flexibility that traditional litigation cannot match. So in arbitration, if you see, there's a speed, there's a flexible decisions, and the traditional litigation cannot match that. That is why arbitration is much more talked about in the town rather than in the litigation. Now, coming to the arbitration versus the court procedure, it is a speed. Arbitration, typically, it's a faster, timelines are flexible and often shorter. But whereas in courtroom, there are delayed due to the overload dockets and procedural requirements. Because definitely a judge may think that your matter is not that much important, which is rather than the other matter. So definitely it will give a more value to that matter. But in arbitration, the arbitrator will solely focus on your matter. He knows that he's being paid to resolve this matter amicably and reasonably. But in judges are not bound to listen your matter in that reasonability. Definitely a judge should do that, but at times there are a lot of backlog that judge have to handle. So in that case, that reasonability will lack in the decision. Obviously, the cost. Second part is arbitration lower the cost in long run, despite the arbitrator's fees, especially in a high volume of complex cases. But in the court, procedural delays can increase the legal fees and other court. If you see in arbitration, in the long run, it will lower down the cost. There is an arbitrator fee which I accept, which is very highly costly. But if you see in litigation, the hearing keep on happening after years and after years. That will also increase the expense. And if you compare the expense, the litigation have more expense rather than the arbitration. Confidentialities. Party proceedings are private and confidential. In arbitration, the proceedings are private and they are very confidential. But in courtroom, the proceedings are generally public, and which bring you to the public scrutiny, which bring you to a lot of public discussion, public disclosures, which you don't want, to the media trial as well as at times. And definitely there will be a lot of hue and cry. There's an environment, the territorial dispute involved, there's an IP issue involved. So other things can also bring out that will increase your risk in the courtroom hearing. But rather than an arbitration, there's no media involved, there's no public involved. Only the arbitrators and the parties are involved, and they reach out to the method of resolving this issue. Next is expertise of the decision makers or the judge. Definitely in arbitration, we do hire the industry expert as an arbitrator. But in the courtroom, the judges may lack that technical or subject matter expertise, because definitely they are aware about the law, they are about of the general nitty-gritties of the law. But we can't expect anyone or every judge to be expert in the every matter. Especially if we expect that judge to be expert in the maritime issues, judges to be expert in the commercial dispute, IP dispute. So we can't expect that to just to be an expert in every matter. So in that case, we cannot appoint the judge, and we don't know how much that judge is expertise in that particular matter who is appointed to hear that matter. But in arbitration, we know that that particular person who is sitting in the arbitral tribunal knows the basics of the arbitration and this particular dispute and the particular things we are dealing with. So definitely there is a huge difference between while appointing arbitrators. Now, the procedural flexibility in arbitration, parties decide the procedure, timelines, and rule. But whereas in the courtroom, you are bound by the civil law, criminal law, and then definitely there is a other procedural laws in that particular country. Let's suppose it's a debt recovery procedure, that is very different. If there's a court of small causes, consumer court, so every court have their own procedure, which we have discussed. So to prevent that in arbitration, there's no as such procedure. All you have to follow is the procedure that you have made. In courtroom, you have to present everything on affidavit. You have to do everything on what judges says. Let's suppose there's a court that required the particular thing to done by in a particular manner. You have to do that. But in arbitration, you can get away with that, and you can strictly come to the conclusion of the matter. Then there's a finality. Awards are generally final in arbitration. with a limited ground of appeal, though there's an option of appeal is available. But in court, there are multi-level of appeals available. If you go to the trial court, then you have to go to the high court. After that high court, you can go to the Supreme Court, and then there's a level of appeals in that court as well. Then the enforceability. Arbitration is easy. Arbitral tribunal awards are easy to enforce internationally under the New York Convention. But foreign judgments are face complex procedure and enforcement procedure to get implementation in the country. So that is why also in international dispute, arbitration is the much preferred method. Then the neutral forum. Definitely, if there's a neutral forum location to be chosen in a cross-border dispute, both the parties will be benefited. But when we go to the court, let's suppose there's a dispute between the party in Australia and party in United States, and the case initiated in Australia, definitely there will be some chances of disadvantage for by the foreign jurisdiction. And then comes the language. An arbitration party choose the language of the proceeding, but in courtroom, the language is chosen by the jurisdiction or by the state. Coming next, if we choose the cross-border joint venture dispute and how these disputes are handled. So let's suppose there are two international companies, they are disagreed over the joint ventures term. Then the arbitration, they can choose to be going to the ICC and to resolve that issue. So how that will transform that, the arbitration can clarify the contract term and establish a profit sharing mechanism and enabling the joint venture to proceed successfully. Definitely, like I've discussed earlier, in international commercial dispute as well as in construction dispute, as well as if you have a multinational infrastructure project and there are contractual delay in that project, then party can opt for this and party can opt for the resolution through arbitration. And that will, what that will do, that will create a sense of security in the investor minds. And definitely the construction project will continue without further delay, and that will highlight the arbitration effectiveness in the complex construction disputes. Now, time, date, and flexibility. Arbitration hearings are scheduled based on the mutual convenience of the parties. And in courtroom, definitely the judge will decide. There are strict schedules. There are public holidays. There are holidays where judge have to be on leave, and entire courtroom has to be on leave because the mostly civil matters and civil matters are only involved in the arbitration. So definitely, if there's a like we have the holidays in the courtroom in May, June, and in the December. But in arbitration, no such things happen. You will decide the time, place, and the flexibility will be upon you. The control over the process, the greater control, the party will have the greater control over the process. But in the courtroom, the procedural law will have the control and the judicial discretion will prevail. And arbitration proceedings are less formal, often virtual. Now you can opt for the virtual. In courtroom, it totally depends upon the court whether it will give you the virtual hearings or not. And there are formal procedure and the environment where you have to plead. And in number of cases, arbitrators solely focus on your case. But in courtroom, there are high number of cases which the judges have to deal in the public manner, in the public matters. And why arbitration is better for commercial disputes? Because they are the technical dispute. The technical people needs to be hired for the tribunal so that they can resolve the matter in a much quicker way. But in courtroom, I think structure is less suited for the commercial cases. Now, global acceptance, definitely arbitration is a globally accepted mechanism. And in the courtroom, jurisdiction limitation can transition matter. So that definitely the jurisdiction matter. Let's suppose we don't have the treaty with that particular country, then it will become very difficult for us to enforce the foreign judgment in our jurisdiction. Then preservation of relationship, arbitration is less adversarial and it preserves the business ties. And in courtroom, definitely there will be not that good relationship because you are bringing the party to the courtroom and making them subject to the litigation for years and years. Then there are customizable remedies. Arbitration can craft the equitable remedies for the both the parties, but the court has to go through strictly statutory remedies and precedents. And next is less public scrutiny. And arbitration issues are so sensitive at times, especially the IP disputes are so sensitive. If we study a case of Apple versus Samsung, and they are so sensitive issues that we cannot bring that issue to the public court and public forum. And in those cases, arbitration turn out to be the bestest option, the best option available. Now, for the court, the public nature may cause a reputational damages to the party. In arbitration, there's a single stage process, only one process. But in courtroom, there's a trial, appeal, and possibly if review is available for that, then you can go for the review as well. Now, why arbitration is much talked about in the town, and why we are talking about arbitration every day, and we are seeing that there are a lot of development in arbitration. So there is a survey which is conducted by the Forum of Indian Corporate Lawyers, and the preferred method of dispute resolution among legal professionals. So, among legal professionals, what is the most preferred method of dispute resolution? According to 61% people, it is arbitration. 11% people think it is conciliation, 14% people think it is a court litigation, and then 11% think mediation, and 3% about the other. So you can see the arbitration, the dominance of arbitration over here. That the most of the legal professional like you and us think that the arbitration is the most preferable method, and we can easily resolve that issue and the complex commercial issue through arbitration only. And the most of the party nowadays, everyone, even the employer and employee, have the arbitration clauses in their agreement, because nobody wants to go to that particular litigation and that long court process where we have to wait years and years to get the justice rather than resolving a matter. Let's suppose if I have an issue with my employer, or any party have an issue with their employer, they can invoke the arbitration clause and they can reach out to the arbitral tribunal, and they can set up the arbitral tribunal and resolve that matter amicably rather than going to the labor courts and then high court and then Supreme Court, trial court, different courts. So the arbitration is turning out to be the most preferable method. Now, so if we talk about the flexibility of procedure, I think what are the perceived benefits of arbitration? Why arbitration is preferred as a most suitable option in the dispute resolution? Because of 30%, 31% lawyers and legal profession believe because of the flexibility of the procedure. 20% believe because of the speed. 19% believe because of the expertise of the arbitrator, 14% believe in neutrality, 13% believe the enforceability, and 3% believe that there are other key elements like the court procedure and all that makes arbitration unique. So that is why 61% lawyers believe in these components of arbitration, and they think that that is why arbitration is the most preferred method of the dispute resolution. Now let's just talk about some cases where arbitration turned out to be the most transformative method for the parties. And one such case is the Apple versus Samsung. In that particular case, Apple accuses Samsung of infringing its intellectual property rights. And property rights for any company is very important. It's very, very important. And both the parties opted for the arbitration, and both the company opted for the international commercial arbitration to resolve this complex international dispute and then transformation. And the arbitration led to the binding decision, allowing both the tech giants to refocus on innovation, maintain their global corporation without prolonged litigation, because both have their IPs involved in this particular case, and the party both the party needs to think about that how they can rather than prolong litigation, how both the parties can work on to the mutual amicable resolution. And the arbitral tribunal and the arbitral award also led to that decision. And because the issue was so complex, if I read out the verbatim, initial verdict, our jury found that the Samsung had willfully infringed on several Apple's patent and trade dress, awarding Apple of $1.5 billion in damages. And some of the matter went to the ICC for the dispute resolution in order to resolve the global intellectual property right disputes. And when both the party came to the resolution that both the party will focus on the innovation and maintain their global operation and recognition that the prolonged litigation. Then comes the other issue, which is Chevron Corporation versus Republic of Ecuador in 2006 to 2018. So what was the issue? In that particular case, let me tell you, the parties involved, the Chevron Corporation was the US-based oil giant company versus Republic of Ecuador. What happened in this case? The Chevron inherited a legal battle from Texaco, which operated oil fields in the Ecuador from 1960 to earlier 1990s. And after Chevron acquired Texaco, it faced a massive environmental damages claim from indigenous community in that particular Amazon region. In 2011, the court ordered Chevron to pay $9.5 billion in damages for the alleged environmental pollution. Then Chevron initiated arbitration in 2006 under the US Bilateral Investment Treaty, claiming that the Ecuador violated the international law. The court judgment was obtained through the fraud and corruption, and the case was heard by arbitral tribunal administered by the Permanent Court of Arbitration in The Hague under the unilateral rules. What are the key findings of that particular arbitral tribunal? Let me tell you: the fraud and corruption in the judiciary. Definitely, the tribunal found that the court judgment was tainted by the bribery, ghostwriting, and undue influence of the party. There was a denial of justice. There was no fair trial in that particular case. There was a breach of bilateral investment treaty and the international obligation under that treaty. And the award was, and UKIDER was ordered to take measure to prevent enforcement of the judgment and was held liable for any resulting damages Chevron may incur. So now this also exposed that how corruption in judiciary can cause a lot of damages to the party, and that can have a lot of distrust among the investor while investing in such a project. So the arbitration transformed that particular thing. Then invest what transformation that was brought, the investor state arbitration validated and reinforced that the utility of BIT arbitration mechanism in protecting foreign investor from potentially influenced or corrupt domestic courts. So the foreign investor now will have more security, more sense of security while investing in any country, and that he will not think that the judiciary will be biased towards its own country. Rather than he can invoke the arbitration clause and can get the arbitration done and get a order in its favor and get a fair trial at least of that particular issue. The president set an important role on how fraud tainted judgment from domestic court may be challenged internationally. And then controversy. This case sparked globally debate over the power of imbalance in investor arbitration and the impact of environmental justice and indigenous rights. So this case was a landmark in case of arbitration, and that is why arbitration was the most preferable method in such dispute, because the judgment which was obtained through the fraud, which we have heard from the newsroom and the newspaper, and quoting as usually as verbatim as I have heard, I have read from the newsrooms. So that is the main thing, that the fraud in the judiciary can lead to a lot of multi-million loss to the companies which are not involved in that particular issue, or even they were involved. So they will not get the fair trial. There will be some bias, which is against the judicial principle. Now coming to the other case, which is Rostro Mining versus Bolivarian Republic of Venezuela, and what happened in that case? This mining company, this company was the Canadian gold mining company, and respondent was the government of Venezuela. And the government, what government did, uh, because they were operating through the joint venture projects and joint venture agreement. So what happened in 2011? Venezuela nationalized all the gold mining industry, and the effectively exploiting the Rostro investment without full compensation. They were given the compensation. They were even not aware about that. So in that case, it lead to the lot of hue and cry amongst the country. And then what happened? Rostro filed a claim in 2012 under the Canada-Venezuela Bilateral Investment Treaty, and the arbitration was administered by ICSID Additional Facility Rules, which is international rules for the settlement of investment disputes. Since the Venezuela had withdrawn from this particular forum, but the claim was still admissible through the additional frameworks. What happened in that particular case? The tribunal ordered in the favor of that particular company, finding that Venezuela violated the international law and BIT treaty and exploiting the company's investment. And the award of $1.2 billion damages to Rostro was given by the tribunal. Now, what was the transformative effect? It protected the investor rights, and it set the precedent and the policy influence. Both were uh, both were talked about globally, that how policy influence can cause lot of million of billions dollars of loss to the company, but they can invoke the arbitration clause and get the justice. Now the next one is Agility Public Warehousing Company versus Republic of Iraq, and in this particular case, the Agility company signs an agreement with the telecommunication or Ministry of Telecommunication of Iraq regarding um, certain services, and the commercial dispute arose from a breach of contract related to telecommunication services between the both, and allegedly claimed that Iraq failed to uphold its obligation under a multi-million dollar partnership agreement. They invoked the protection under Iraq Kuwait bilateral treaty, investment treaty, and ICSID rules, which is International Center for Settlement of Investment Dispute, was sought, and the agility sought the compensation for wrongful contract termination and damages to its investment. There were certain issues like jurisdiction, expropriation, fair and equitable treatment, annulment proceeding. All disputes were discussed, and the party were given justice according to that. Now comes to the WIPO expedited arbitration. In this particular case, a US software company alleged that a European company's security software failed to prevent unauthorized access, leading to the contractual violation, potential reputational and financial damages. This was a technical dispute involving complex question around software functionality, liability for data breaches, and performance standard. The dispute was governed by the licensing contract that include arbitration clause as well. Under the rules of World Intellectual Property Right Organization, which is a WIPO, which we call, the parties agreed to use WIPO expedition arbitration rules, emphasizing the speed, confidentiality, and technicality of method, and the expedite process allowed a quick resolution, avoiding the costly and prolonged litigation, and the neutral arbitrator with the technical knowledge helped to interpret the software compliance and the breach claim. And what happened in the last was the new agreement were signed, new licensing agreements were signed between both the parties, preserving their business relationship and damage to their reputation. And it resolved the most complex technical issue between both the companies. The same comes the arbitration trade coexistence dispute. Now, all the IPR issues are nowadays resolved through people expedited arbitration only, because it is the global recognized body. They have their own rules. They are the neutral body and they don't have biases as such. So, in this dispute, in this particular case, the parties' names are confidential. That is why arbitration is well known for keeping the information of the party confidential. A European luxury good company and an Asian manufacturer had a conflicting trademarks. So their trademarks were so similar that it can impact their market, the damages, their reputation in the market. So both the party reach out to the WIPO expedited arbitration, and after that there was settlement between both the party to operate in their respective market, showcasing the it showcased how arbitration role in resolving complex IPR issues. So both the party have such a similar trademark that it can cause a confusion to the public, and such a confusion that which one is real, which one is fake. So in order to prevent that, in order to prevent the public debate about that, in order to prevent the confusion among the consumer, the settlement were done between both the party regarding their respective markets. Now we have already discussed the cross-border joint venture dispute. Definitely, there are if joint venture dispute, you can go to the ICC and other forum. They will have a resolution through profit sharing mechanism and the contract terms, and they will enforce the treaty and by BIT and whatever agreement you have signed. So that will help you to get a more sense of security while doing your project. Same with the construction project as well. Now coming to the intellectual, this one. Now coming to the intellectual property conflict between the tech companies. So definitely these tech disputes are also resolved through the arbitration. Both the parties, in order rather than going to the litigation, they can prevent that. Rather than they can opt for the such kind of dispute resolution method. Then the distribution agreement in agriculture sector, Austria and Turkey case. This is very important case. In this case, what happened? The Austrian and Turkish companies had a distribution agreement for the agriculture projects like seeds, chemical, and machinery. One party alleged that there was a breach of contract, possibly over the delivery failure, territorial exclusivity, and pricing matter. And there was a risk of commercial fallout, especially during the planting and harvesting season. What happened? The party reached out to the arbitration, and in arbitration through the UN Convention on Contracts for the International Sales of Goods. And what happened in the arbitration? There was a neutral venue. Both the party were given the neutral value because the different legal system may cause more conflicts. And it enabled a resolution within the 7 months. They both the party reach out to the resolution. You can understand the how much quick it was within the 7 months. The resolution of the particular dispute was given, and it maintained the supply chain. So definitely the supply chain is a very complex industry because I work with the supply chain. I'm a part of logistic industry only. So I can understand each and every minute is very crucial in the supply chain industry. Each and every minute. So if we wait on the court hearings years after years, we will get the justice. It will result into the huge loss. So in order to prevent that loss, we have an arbitration in place and party opting out to the arbitration. So now you can understand from the contract dispute, employment dispute, now to the agriculture dispute. These disputes are also coming to the arbitration. So the arbitration arena has increased. Now, coming to the most talk about arbitration nowadays, the sports arbitration cases. Definitely, whether it was a Vinesh Phogat case, we have heard a lot of things that we are going to the CAS for the justice, and our court of arbitration needs to hear that particular matter. And the sports law are getting interpretation through arbitration only. So there are a lot of sports law interpretation nowadays because the gaming laws are there. Nowadays, party reach out to the arbitration, and that helps the party to prevent to prevent them from the unfair treatment, get them justice. So this is very important for them. So what happened in this Castro case? Castro versus World Athlete case, the South African athlete challenged the World Athletics regulation requiring the certain athletes with a certain testosterone level to take medication to compete in women's events. So this party went to the court of arbitration, and this case sparked the global outrage. There was a global outrage about this particular regulation. Case went to the arbitration under CAS, and it increased the awareness and discussion on the inclusivity and the right of intersex athletes. Now comes to the another case, City of Manchester versus UEFA. UEFA banned City of Manchester from European competitor for alleged breaches of financial fair play regulation. And in this particular case, what happened? Let me read out the facts. The UEFA banned the City of Manchester from European competitor for 2 years due to the alleged breaches of financial fair play rules. Manchester City denied the accusation and appeal. The case was appealed to CAS under the UEFA's disciplinary procedure and arbitration clause. And the legal issue included the interpretation of financial disclosure, due process, and burden of proof. The case overturned the ban, citing the insufficient evidence and procedural errors, and the ruling protected the Manchester City right to due process and the importance of transparency in the sport governance, and reaffirmed that CAS roles as a neutral watchdog over the powerful sporting body. So nowadays, the CAS, the Court of Arbitration in Sports, is acting as a watchdog or as a neutral body who's looking that which sports governing body is doing illegal activities, unfair treatment to the athletes. Because when we come to the international forum, we need to have an inclusivity. We need to have fair treatment for every across gender, across religion, across territory. We cannot ban some athletes on unnecessary basis. So definitely now CAS is acting as a watchdog over there. So that is a great development in the arbitration cases. Now coming to the territorial disputes. If we see Lingitan and Spindon Iceland dispute, Indonesia and Malaysia both have this dispute, and both were claiming the sovereignty over these Iceland. Both party went to the ICJ, arbitration through ICJ. And what happened in this particular case? It was submitted to the International Court of Justice, functioning as an arbitral tribunal under international law. The court applied the principle of effectiveness, and colonial boundaries remain unless changed legally. ICJ ruled in favor of Malaysia, citing effective administration and the peaceful submission to the international adjudication, averted the escalation or armed conflict, set a precedent for handling other maritime and land disputes, and strengthened the ASEAN regional legal cooperation. So, in that particular case, due to this arbitration, what happened? The armed conflict was stopped. The armed conflict was prevented in this particular case. So there was no armed conflict between both the parties. The precedent set, this was a precedent which was set for the other maritime dispute as well as other land dispute as well as, and it strengthened the ASEAN legal cooperation. So there are ASEAN countries and their legal cooperation was strengthened to this. Now coming to the other issue between Singapore versus Malaysia is a Pedra Barca dispute. And what happened in this particular dispute? Again, they were claiming the sovereignty over this particular land, and ICJ made the ruling. ICJ made a split ruling. The Pedra awarded to the Singapore, Middle Rock to the Malaysia, and Southwest to be negotiated based on the territorial waters. And both the country accepted the decision, which diffused a sensitive geopolitical issue, illustrated that lawful adjudication can replace the nationalist rhetoric and reinforce the role of legal diplomacy. So this is how arbitration is taking place across border. Now it is resolving the territorial dispute. It is resolving the legal dispute or among maritime dispute. So it have now a lot of things to do with arbitration. Now coming the other case is Chagos Marine Protected Area arbitration case. It was between Mauritius and United Kingdom. And Mauritius, the UK declared the marine protected area around this particular area which Mauritius claimed violated its sovereignty. Mauritius argued that it had been unlawfully excluded from the negotiation during the UK's colonial withdrawal. And arbitration was conducted under United Nations Convention on the Law of Sea, and Mauritius claimed that UK breached obligation under international environmental and decolonization law. The tribunal ruled in favor of Mauritius, finding that UK's declaration was inconsistent with the law and reinforced the decolonization right and challenged the UK authority over the territory and supported environmental governance through the legal mechanism balancing the sovereignty and sustainability. So you can understand through these cases now arbitration is reaching to the new level. And now we are discussing about the decolonization law. Now party are challenging their sovereignty, resolving the dispute of sovereignty, their territorial sovereignty, water sovereignty, airspace sovereignty via arbitration only, rather than going to the hardcore litigation process, rather than going to the war. So now arbitration is resolving the warlike situation as well. Now comes to the another case. It was a Beagle Channel arbitration case, a maritime and island sovereignty dispute over the Picton, Lexan, and Nueva Iceland. The conflict brought Argentina and Chile to the brink of war in 1917, and the matter was submitted to the binding arbitration under the 1971 Treaty of Arbitration, with the Queen Elizabeth II acting as an arbitrator through the appointed jurist, and the tribunal ruled in favor of Chile, and the treaty resulted in peace and friendship among both the countries. So this is how the bilateral relationships is how the countries can save the relationship rather than going to the war, rather than going to the courtroom process, rather than going through its normal process. Now you can opt for the international, rather than going to the at length. We can have this arbitration clause as a play. Cases in which arbitration is playing a transformative effect can have a transformative effect is an international dispute. Arbitration under bilateral investment treaties offer a neutral forum for resolving investor state dispute, often resorting investor confidence in influencing reforms. Then comes the technology and licensing issues. We have discussed that as well. Life sciences and pharmaceutical issue. Arbitration can resolve IP, royalty, quickly continued the R&D issues as well as infrastructure and construction dispute, maritime and shipping disputes, environmental dispute, media and entertainment dispute, because there are copyrights involved. There are which is artistic work which is involved in the media and entertainment as well. In order to protect that, sports dispute, we have already discussed that, and then real estate and commercial leasing dispute, and data privacy and cyber security, data sharing, data transferring through GDPR and other tech through GDPR. Tech can use an arbitration to prevent their privacy and to in order to stop violation of their privacy, and then they can rebuild the user trust in that. Now coming to the most uh, next one is aerospace and defense contract. Definitely in defense contract, there's a lot of things which are confidential, which countries don't want that it should be disclosed in the public. So definitely they'll go to the arbitration clause only. And the sovereign debt and financial clause as well are submitted to the arbitration only. Now coming to the most talk about debate is the Indus Water Treaty. India has stopped the water of Pakistan through this treaty, or let's see whether Pakistan invoked the arbitration clause with this treaty, because this treaty has having an arbitration clause. The Indus Water Treaty is a water sharing agreement between India and Pakistan, brokered by World Bank in 1960. It governs the use of water from the sixth river from Indus River, basic structure of territory, eastern river Satluj, Beas, Ravi allocated to India, and then the western river like Indus, Jhelum, and Chenab, largely located to Pakistan with India, allowed limited non-consumative use like hydroelectric projects and irrigation uses. And let's see, there are methods of resolution in that treaty as well, whether there will be a permanent Indus Commission composed of one commissioner from each country, handle technical issue and routine matters. Most disagreements are resolved at this level only. If not, then there will be a neutral expert. And then we have a court of arbitration, which will be having a seven-member committee. And that process will include the hearings, evidence review, and binding decision. And the World Bank can facilitate that resolution or that arbitration. So now we have to see. Now we have to see whether. Now we have to see whether the World Bank or arbitration tribunal will be able to resolve this issue, because India is now full-fledged ready to stop the water of Pakistan. Let's see how this case develops. This will be a case study for all of us who are studying about arbitration nowadays. Now coming to the conclusion. So the conclusion is the arbitration is a constructive resolution rather than you seeing as it as a parallel to litigation or alternative to litigation. It is a parallel to litigation. It preserves your relationship. It is much more speedy. It is more less complex and less time consuming. It is more preferable to both the parties. It helps both the parties to preserve their relationship. It balances their collab. It is much more of collaboration rather than confrontation, because in litigation there is a confrontation, but in arbitration there is a collaboration. You reach out to the mutually agreeable resolution of a dispute rather than having one party to be punished for its deeds. So we reach out to the mutually agreeable resolution in that particular case. And then our global challenge grow more complex. Arbitration relevance, adaptability make it a cornerstone for modern dispute resolution. Nowadays, we know that enforcing foreign judgment is itself a task and a very expensive task. But in arbitration, it is it is definitely enforceable across the borders. So let's see if any one of you have a question, we can discuss that. And this is all from my side.
So thank you, Mohit, for your valuable insights. So I would request the participants if they want to ask any question from Mohit.
Thank you so much, Divya. Mr. Sani, this was a very grateful and very insightful session for us on the arbitration. I just had a query. Like for the arbitration, recently there is a so much chaos by the retired Supreme Court judges saying that they are like more inclined towards the having the institutional arbitration instead of ad hoc arbitrations. What's your thought about it? Like institutional arbitrations are much better than the ad hoc, or ad hoc is more preferable?
I think I will not rule in favor of one thing rather than doing just injustice to other. I think both arbitration have their own merits and demerits. Definitely, the institutional arbitration is most favorable because everything is done by that particular institution. But we cannot just overlook the value of ad hoc arbitration in that particular case. So both have their equal values. Our Supreme Court judges may have their own views, but I think they were inserted with a certain view. Ad hoc arbitration was also inserted with a view that it will do the justice, and the party may appoint the arbitration according to their own will. And the institutional arbitration was also inserted with a view that it will get a more easier and more quicker justice to the party. So both arbitration, I guess, are preferable. There should not be a debate between the institutionalized and ad hoc arbitration. So I'm not in the favor of any one of them. I think both of them are preferable, because our only I think our only aim is to reach out to the resolution of the matter in a very easy and less complex manner. I hope I have answered your question.
Yes, yes, yes. Thank you so much, Mr. Sani. Also, when you consider the country like India, wherein we're still developing to the jurisprudence of interpretation of contract, and also to the the reference to the arbitration and seat and venues, the all-exotic argument before the courts. So, what do you think? What kind of approach such countries, such developing countries, should take for the resolution of the dispute through the arbitration?
Definitely, India is a developing country, and we are almost in the urge of becoming a developed country. And we are the country which has maximum number of economic resources, be it land resources, maritime resources, and we have every industry available with us. So arbitration and the seat of arbitration, definitely it's a big issue. And but I think that will be much more better issue if we can have a seat which is more convenient to all the parties, and which can resolve this issue in a much more quicker way. And I think the government should think about it, that now Arbitration Act also needs and they should be rethink that what are the that current Arbitration Act, what are the lectures that the current Arbitration Act of India is facing, and we can have an amendment with involving all the stakeholders, whether the companies, whether the arbitrators or the law bodies and the law commission, and we can reach out to the conclusion that this is the most suitable seat for the arbitration, and this is how we can resolve the issue. Because by today or tomorrow, we have to reach out to that conclusion. We have to find that particular resolution, because India, as a growing country, as a developing country, today we are also opting for the arbitration, and we are also in urge of becoming an arbitration hub.
That's right. And what would you say for the judgments? Like recently, if you have read the Singapore court's judgment, wherein the court have set aside an arbitral award passed by the ex former CJI of India, and there were, because of the certain paras of the award was copy pasted by from the earlier awards. So, what should be the recourse in such cases? We should opt for avoiding such difficulties and such disputes in the future for arbitral awards, basically.
I think, with all due respect to justice, and we have, all have heard about that justice, and he was a very prominent judge in India because he have held the position of CJI, and that was quite shocking for all of us when such news came out in the public that particular award was copy pasted. Definitely, I think now, like the PhD institution, also need to have a plagiarism check in the awards, and the judges have to prove their uniqueness in the award, and the proper citation should also be there in the award. So definitely we should have certain sort of mechanism to checking that, as well as to saving ourselves from the international embarrassment or embarrassment from the public. Because when such things are caught in the plan, plagiarism came out in the public, that news was very shocking to everyone. Because that particular justice was very learned justice. We have read his judgment of in our law schools, and today also we judgments, and his writing is he writes very nice judgment. So it was quite shocking for all of us. But if in case such dispute arise, where party challenges and where the even the court is setting aside the judgment on the basis of copy pasted material, so we need to have a plagiarism check in such cases for the arbitral tribunal awards, as well as, and they are properly cited even if they are copy pasted. So I think the due recognition of the work should be given to the author who have written that book. So I think we need to have such thing as well. Generally, if we see the institution where you have to present your thesis, you need to present your uniqueness, your plagiarism check report through the website like Turnins and everything, which certified that your content is not AI generated, your content is not copy pasted, and this much content is unique, and this much content is copy pasted. So I think that needs to be also presented to the courts nowadays, and let's see what happens, whether government focuses on such thing or whether it will be a next debate coming in across global.
Thank you so much, Mr. Saini. This was a grateful insight. This is all
Thank
from
you.
my side. Thank you.
Thank you. Thank you so much.
So thank you, Mohit, for imparting your knowledge with us. So I think that's all for today, and we'll be in touch.
Thank you. Thank you so
Thank
much,
you.
Divya. Thank you, everyone. Thank you, everyone, for inviting me. Thank you.